Submitting late the form, the I-751 petition to remove conditional residence. If you have a good reason for filing late or qualify for a waiver, it would like to be worth submitting Form I-751 even after deadline. Foreign nationals who get green card on the basis of a marriage that less than 2 years old are considered conditional residents. This means that their green card will expire after only 2 years. In order to become a permanent resident, they will need to petition either jointly with a spouse or individual with a waiver request to remove the condition on the residence by filing Form I-751 within the 90-day period before the green card expiry date. For various reasons, however, some conditional residents fail to their petition on time. Such person might assume they have been already ordered deported, most likely because they missed a deportation hearing, be able to file their I-751 late. However, conditional residents who intend to file jointly with a U.S. spouse cannot become permanent residents unless the government, U.S. Citizenship and Immigration Service, or USCIS, is satisfied that the late filing can be excused for good cause. If you're applying for a waiver at the joint filing requirement, you don't need to prove good cause. In other words, the fact that someone whose marriage is ongoing simply forgot about or overlooked the deadline would likely not be accepted as sufficient reasons for late filing. U.S. immigration laws and regulations do not actually define what good cause means. However, UCS have issued certain policies to guide its decisions on late I-751 petition. Why conditional residents should file I-751 even if it's late? Conditional residents who fail to file this form, the I-751, can no longer use their green card for employment and travel purposes. They may also be placed in removal or deportation proceedings. Filing a late I-751 petition could avoid some of all these problems. For one thing, it opts to change that UCS rather than immigration judge will decide the application. In the past, conditional residents who were placed in removal proceedings were often granted what is called continuance or postponement of the hearing so as to have time to file this form, the I-751, at UCS and get the answer. The answer will then be reviewed by the immigration court. Under the Trump administration, however, before immigration judges have been discouraged from the granting continuance unless they themselves think there's a good chance of UCS approving one request. Proving the good cause for filing late joint I-751 petition. Hear closely. UCS has broad powers or discretion to determine the meaning of a good cause for filing late and will process applications on a case-by-case basis. The agent current policy recognizes the following example of good cause: being hospitalized, or long-term illness, obligation or grief related to the death of a family member, legal, financial problems, having to care for someone such as an alien spouse who's sick, a serious family emergency, work commitment, or having a family member active duty with the U.S. military. Other circumstances could certainly fall under the definition of good cause. It will be up to you to identify and provide evidence of this if you simply forget to turn in your joint I-751 on time. Try to think of circumstances in your life, be they work or family related, that could explain your memory lapse, and then as an attorney, if such circumstances will be framed in terms of good cause. You cannot claim UCIS failure to notify you a coming deadline as good a cause. However, keep in mind, that the longer the length of the time I-751 petition is late, the most difficult it may be prove good cause under any circumstances. The procedure to follow in filing an I-751 petition: if you will need to file late a joint I-751, be sure to submit a written explanation of your good cause for the delay. Under current UCIS policy, if you fail to submit with an explanation, you will first receive a request for evidence, RFE. Then you will fail to submit such explanation. In response to the RFE, your I-751 will be automatically denied. It is also very important, although not technically required, to support the explanation with documents attached as evidence. For example, if you're claiming good cause based on the death of a family member, you should probably submit a death certificate and evidence of relationship to the descendant. Here again, if you had not already done so, UCIS may send you an RFE. If you haven't already sent your RFE, you is not yet convinced that you have established good cause, it may schedule you for an interview. There will be last chance to present your case in more detail. Otherwise, the agency could decide to deny your case on the I-751 right away. The possibility for travel after filing late I-751 petition: you might be allowed to travel outside. You might be, and return with your I-797 receipt and a copy of your expired conditional resident card under temporary I-551 passport stamp, in spite of the fact that you filed the I-751 late. Still, it might be more prudent to wait until you receive the decision before traveling. Technically, conditional resident who fail in the timely I-751 petition to remove conditions on resident automatically lose their status. As a result, one might infer that such persons, upon filing, will not be able to use the work and travel extension provisions of the I-797 received while their case is pending. The reasoning being that since the status was lost, it cannot be logically be extended. However, in practice, conditional residents who file late an I-751 petition can be allowed to work and travel with their I-797 receipt, especially in cases where the conditional resident files online. Requesting a waiver of the joint filing requirement based on divorce, abuse, or hardship, unlike conditional residents who file their I-751 jointly with their spouse, I-751 petition who file alone are allowed to file their petition at any time, or at least so long as they have not already been ordered deported. Accordingly, they are not required to provide any explanation for their tardiness. In contrast, while joint I-751 petitions will be required to provide for good explanation or good cause for filing late. As a result, it's easier to argue that late I-751 waiver petition should be allowed to travel once the petition is pending. That said, the safest bet is to wait until receiving a decision on the case before traveling, just in case the petition is denied and you're placed into removal proceedings while you're abroad, which means it will be more difficult to keep finding your case consult an attorney for a full analysis. Remember to subscribe to my channel, activate notification bell to receive notifications when I upload new videos, like, comment below, and share. Have a blessed day.